Good morning. Come gather round, people wherever you roam, and admit that the waters around you have grown. You better start swimming, or you'll sink like a stone. For the times, they are a-changing. 60 years after Bob Dylan sang this prophetic song, we now again find ourselves in times of change. Profound change. However, today's transformations might not be the progressive ones that Bob Dylan was singing about. We see ourselves in a different trajectory, one that is marked by deglobalization, the rise of nationalist movements, dramatic shifts in the global order, and wars on the continent, both kinetic and economic. Now, what we are seeing is that these developments are reshaping our own fields, here of data privacy, correction, and technology policy. And what we are also unfortunately seeing is that it means we are deprioritizing fundamental rights. What the panel today will do is address the critical question of what it means in a rapidly changing and evolving world to be doing regulation on AI and cloud computing in the European context. What we have seen is an ambitious push for Europe's digital landscape. EU officials, however, are now saying that the times are changing. Rather than enforcing the digital rulebook, the European Commission is signaling potentially revising these same rules as part of broader initiatives to enhance economic competitiveness and through regulatory streamlining, which long were taboo. What we are seeing right now is that Brussels' shifting focus means simultaneously stepping back from regulation while also fortifying European sovereign technology through industrial policy. And these twin processes are creating a real stress test, as per the title of this panel today, for Europe's digital rulebook, as well as for the ability of Europe to protect fundamental rights and values. Now, the apparent changes in this water have raised concern amongst our esteemed panelists as well. So today, in the order that they will be presenting their opening provocations, I'm going to introduce you first to Associate Professor Dr. Seda Gürses of the Technical University of Delft, who is a leading thinker in the field of institutional transformations brought by what she calls computational infrastructure, or the combination of cloud and end devices. And I think one of her most recent pieces is set to ruffle feathers here, as it was titled, Misguided, AI Regulation Needs a Shift in Focus. After which, we will hear from Maria Donde, who is the International Affairs Director at the Commission Namean, the media and online safety regulator in Ireland. And she leads its program of international engagement, overseeing the relationships with the European and global institutions. She's also worked at Ofcom for many years. After which, we're moving to Kai Zenner, head of the Office of Digital Policy and a digital policy advisor for MEP Axel Voss in the EPP group in the European Parliament, and a Brussels mover and shaker on all things digital. He is a has a self-proclaimed soft spot for interinstitutional reform and the better regulation agenda, which I hope will come out today. And then last but certainly not least, Dr. Isa Stasi of Article 19, who is the head of law and policy for digital markets. She's a competition lawyer with a background in media, telecoms, and digital sectors, and she leads Article 19's law and policy endeavors concerning digital markets. And as a nice aside, she has also recently sued Microsoft before the CAT for what she argues are abusive practices in cloud licensing. And just to mention, my name is Corinne Kat. I'm an anthropologist studying cloud computing and internet governance, and I'm currently the head of digital, the global team digital at Article 19, where I lead a team that works on all things infrastructure, including engagement in the standards around AI. Now, our conversation today will examine how we can ensure AI governance remains firmly grounded in the rule of law and fundamental rights, as the water around us have grown. So a little bit of housekeeping for today as the last people trickle in. All four panelists will open brief opening provocations, about 5 minutes each. Then I will facilitate the conversation among them, and then finally we will open up the conversation to hear from you all in the audience. And with that, please join me in welcoming our first speaker, Dr. Seda Gürses.
Can you hear me? So thank you, Corinne, and thank you, Article 19, for putting this panel together. I've been asked to open the frame, to enlarge it. I'll probably do that maybe too large, but bear with me. So for those of you who've been around CPDP longer, you may have noticed the .ai added to the acronym. Does anybody know why? Who knows? All right, so I'm not here to tease the organizers, but I want to reflect on a trend we see over time, and I'm going to ask your help with it. Tech companies keep throwing shiny new objects at us. It was at some point, big data, then it was IoT, the metaverse, Web 2.0, Web 3.0, crypto, AI, and now generative AI, agentic AI, quantum, anyone? Okay. I can ask you any other terms that come to mind that you might have. Blockchain, yes. Anyone else? Ambient intelligence. Ubiquitous computing. Do you remember that one? Okay, all right. So it goes on and on. So while these terms sound the bells of the next revolution every time, they actually maybe mask deeper infrastructural changes that brought them to bear that I want to focus on today. So I fear that these buzzwords distract us from the deeper institutional and economic transformations these companies are driving. How so? Every time a new technology emerges, experts, like many of you in this room, including those in government, civil society, and business, turn to wrap their head around its workings. What are the risks and societal impact of big data, AI, et cetera, et cetera? So we then map the risks to these technologies. Big data to privacy, AI to privacy and bias, generative AI to more privacy, IP, hallucinations and errors, et cetera, et cetera. To be fair, some prescient work here goes beyond just the objects of themselves. IoT, for example, in the case of smart mobility, raises concerning labor questions. AI's gas-gurgling, mineral-melting infrastructure has led to great work that looks at global supply chains, securitization, militarization, and forms of neocolonialism. But overall, most tech policy narrowly focus only on the immediate technical effects of these objects rather than their structural impact. So what if we zoom out and ask, why are these businesses throwing these technologies at us and not others? Why AI and not something else? Why blockchain and not something else? And trust me, the answer is not scientific breakthrough. And let me spend the next minutes to propose one way to answer that question. And we can put holes in that story or look for others as well. So let's take a brief historical view. Since the 1950s, the business of computing has been trying to solve one big problem: how to produce software on time, within budget, and in a way that's profitable. Over the decades, their revenue has relied on developing business-to-business applications. These are solutions that help businesses operate, such as billing, inventory, logistics, supply chain management. These companies digitalize and in the process transform business operations. This is what they do for 70 years, okay? If we take this history seriously, what drives the creations of these shiny technologies, including AI, is not consumer demand, but the at times artificially generated needs of businesses. These technologies are often designed for other companies to adopt. Us consumers are typically on the periphery of this process. So a pivotal shift happened after the 2008 financial crisis, when major tech companies used their cash reserves to create closed environments for software production, what today, or in our group, we call computational infrastructures, made up of clouds, plus all our end devices, so these computers, your smartphones, and IoT devices, as its accessories. So it's a combination, it's not just the clouds. And to make it more concrete, Microsoft transitioned from being a software company to a cloud company, meaning they stopped being a company that produces software to one that produces an environment in which others can produce software, including themselves. And companies like Amazon, Google, and Apple followed suit. In the process, the industry flipped IBM's model of pushing a mainframe at the heart of each business. The cloud instead manifested a pool effect, pooling end devices, ICT department, eventually finance, accounting, if not the whole business, to them. So what does this have to do with AI? Any business that wants to develop economically viable digital services today practically has to go through the computational infrastructures of Microsoft, Amazon, Google, and Apple. Agility, I will not expand, but just go with it, in this environment helps turn software production into an ongoing relation subject to economic experimentation. These experiments are visible to us consumers in the form of changing subscription models and feature updates. You can imagine if you control this production environment, you can also shape it with tooling and models of production with some self-interest. So we can imagine that Google, Apple, Amazon, and Microsoft shape this production environment to their own interests. Generative AI is a notable example. It promises operational gains for businesses. You must adopt, otherwise you can't be competitive. It claims to transform software production, including forms of experimentation. And to reap these benefits, it requires computational infrastructures that are in the hands of these companies and that are really hard to afford by anyone else. From this production view, the adoption of generative AI is aimed to increase the gravity of computational infrastructures. As more businesses integrated, they'll be drawn deeper into these closed production environments, which are made not just for technical, but also economic transformation. If successful, these environments have the potential to reshape economic production broadly and in ways that serve the interests of the companies that control these environments. If they fail, business and governments might find themselves trying to extract themselves from these closed ecosystems, devices, ICT department, finance, accounting, one at a time. Whether they succeed or fail, the structural transformation of computational infrastructures may bring about should be on our horizon, but are mainly out of our view because we discuss big data, IoT, AI, et cetera, et cetera. So let me take a moment to make the impact of these transformations in production on our societies palpable. So last week, news went around that the International Criminal Court was paralyzed due to sanctions from Microsoft, a response to their arrest warrant of Netanyahu due to crimes against humanity. Similarly, Apple and Google Play do not work in Russia due to sanctions. But these frame the problem as one of an off switch. If we go more deeply into the production question, we find other effects. Like when our public institutions notice that once they have done the CapEx to OpEx transition to the clouds, i.e. they decimated their ICT and cloud centers and went to the cloud, they cannot exit the cloud without a massive injection in public funds for our building a decades-long project of an alternative infrastructure. Or when the planned obsolescence of end devices like smartphones, right, you change them every 2 years, expands to things like cars, which as they become software-defined, are expected to have a lifetime of 8 to 10 years. That was what a lot of our industry depends on, right? Or when the energy grid in Norway were bound by contracts to feed the TikTok data centers rather than weapon makers. That was maybe not so bad. And maybe most exemplary, how renewable energies, by now 70% in this trade, how renewable energies, agile through and through, have attracted energy traders that made billions of profit from the volatility of the war in Ukraine, a completely software and cloud-driven service. So there you see really the experimentation of agile production in the grid and then financial trade on top of it becoming like this amazing amorphous thing that tells you where the future is kind of going. So here's my takeaway. The focus of tech policy and regulation shouldn't just be on discrete harms of shiny technologies like AI or IoT or blockchain, you fill in the blank. While important, they may obscure the bigger societal transformations computational infrastructures are pushing forward. Thank you.
Thank you so much, Teda. Thank you so much, and you have also incidentally provided a perfect bridge from a call to regulators on what to focus on to Maria, who will be speaking from that perspective.
Thank you very much. Thank you. Great to see so many of you here today. This is my first CPDP, so I also wondered why .ai had been added, as anyone knows. Firstly, please be gentle with me. I'm from the regulatory community, and I have not attended this conference before, but it's a real pleasure to be here. I thought I might just briefly say a few words about my organisation, as it may not be necessarily so familiar to many of you. Commission Demand was set up 2 years ago as the new online safety and media landscape, media regulatory body for Ireland. It was, as I'm sure you're all aware, a particularly important institution to get right and to resource properly, because we are responsible for the oversight. We are the Digital Services Coordinator, and we're responsible for the oversight of a number of very large online platforms that are headquartered in Ireland, with whom, of course, we share oversight responsibilities with the European Commission under the DSA. So we are a new organisation, if you like. We're created on the basis of the old media regulator, the Broadcasting Authority of Ireland, who had some experience in some of these areas. And I think it's interesting that we were given those duties in relation to online safety and online platform supervision and oversight as the media regulator, because we bring, of course, a particular approach to some of these questions, which perhaps some of the more technocratic and infrastructure regulatory authorities might not necessarily to these tasks. And I mention this because the focus of today's session and the focus of today's discussion is about fundamental rights, and a big focus of this conference too. And I just wanted to mention that we published our strategy, our first organizational strategy, a couple of weeks ago, really, and it's taken us a while to set out our approach. And one of the things that we focus on in that strategy, and I read this out in case I get this wrong, is we see ourselves, our mission, as ensuring that the media landscape, and by that we mean across all media and across all distribution mechanisms, serves the public interest and underpins fundamental rights. So our entire raison d'etre is committed to and is underpinned by that basic principle. When it comes to, and so I'm really looking forward to the discussion here today, and I won't talk for very long in this introductory section. When it comes to the questions of the risks posed by AI technologies, we, as a regulator responsible for online platforms and the media, have recourse primarily to the DSA. I think that's the most relevant and the most central piece of the regulatory framework for which we are responsible and what we look at. Now, as I said, we share some of those responsibilities with the European Commission and with our fellow digital service coordinators around Europe. And one of the things I always stress is the importance in this context of collaboration and cooperation between regulators. That's important in the context of understanding systemic risks, because the way that the Digital Services Act is set up is that we are responsible as a collective of regulators for understanding risks posed by digital technologies within the scope of the DSA to citizens and to users. There is concrete and specific references to the risks posed by AI in relation to the use of online platforms and very large online platforms within the DSA. They're explicitly mentioned and they're discussed, and it is our responsibility as regulators to monitor, to assess, and to understand those risks. And of course, we are not the designations in relation to the AI Act and regulatory responsibility have not been made yet in Ireland. So we have some role as a fundamental rights authority for the AI Act, but that's the limit of our responsibilities so far. We will have those responsibilities. There are just two things I wanted to say about the approach to understanding systemic risk in these contexts. The first is the way that the frameworks have been set up, including the AI Act, but primarily the DSA, is that it requires some iterative work to be done over potentially several years in order to really understand what kind of risks we're talking about. The frameworks are set up in a principle-based, structural way, so that it is the responsibility of the providers to assess the kinds of risks that they think are posed and to propose mitigations for them. That kind of principles-based approach means that it may take some time until we really identify what the right regulatory levers, what the right mitigations are, and what we as regulators can do to enforce those. That premise has some challenges associated with it, and we can all hopefully discuss those challenges in a bit more detail. Coming from my background in Ofcom, I would contrast that, for example, with the approach that Ofcom has taken, although it's not, again, not specifically focused on AI, but under the Online Safety Act, to produce very, very detailed and quite prescriptive guidance about how risk should be understood in the online environment. And that too has still time, we still need to see how that will work, but those two approaches can be contrasted in this context. The second thing I wanted to say before I move on is about regulatory expertise and just come back to that point about partnerships and collaboration and cooperation. We are not experts in AI. In fact, we are not experts in quite a lot of the things that we spend our time regulating and overseeing. There are different approaches to upskilling regulatory institutions, and we again could contrast Ofcoms with some of the other regulators across Europe. But what we are, I think, and what we will increasingly need to be, is experts at finding partnerships and expertise outside of our organizations in order to be able to inform our work. That means also working with other regulators from different sectors, because the connections and the kind of the issues and the risks that we're talking about are going to come from all kinds of different directions. So for us, we will also need to work, for example, very closely with some of those infrastructure regulators that I talked about. And so we create networks and collaborations between regulators in order to be able to do that. And not all of those regulators are necessarily as used to focusing on fundamental rights. So that's, I think, something that we can bring to those discussions. So I think I'll probably pause there, and hopefully that was a sort of a brief introduction into the approaches and to the nature of how we're looking at things from the regulatory perspective. But I'm very, very happy to dive deeper into any of those issues and to answer any questions.
And we'll make sure that happens during the panel and the Q&A. Taking the theme of the deep dive, I'll hand it over to Kai to give us a bit of a lay of the land of where the EU is at right now.
Yes, thank you very much for the invitation. And indeed, I would give you a little bit of feedback how the different EU institutions are tackling the topic of AI governance, or in more broadly terms, even digital policy. Maybe first of all, to start with something more positive. Axel Voss and I, my boss and I, we are, of course, principally very happy that there is finally, let's say, a shift away from regulating more and more and more in a very incoherent way towards an understanding that maybe we did a little bit too much in certain areas. Even more, we were not coherent, as I said, we were not enforcing our rules and so on. So in principle, as I said, Axel and I, we were really happy with the Draghi report, with the letter report, with the following discussions. But unfortunately, it stopped there in our feeling and impression. Because if you really look what the European Commission is now doing, is basically, in our eyes, a buzzword like digital policy making with fundamental rights focus was replaced by a strong focus now on competitiveness, on economy, and so on. Which, again, especially for our group, for the EPP, it's definitely something that should have been done more before, but kind of completely ignoring what has been done before, shifting really most of the focus away from fundamental rights, and again, going extremely narrow in those topics is really the wrong way to go. This new narrative, as you all had, for example, the consequence that the Commission was proposing the withdrawal of the AI Liability Directive. My boss and I were furiously pushing against it, and let's hope that the Commission is changing their mind. We don't believe they will, but the Parliament until now is continuing to push against this decision. And going back to what I said before, for us, content-wise, it doesn't make sense, legally it doesn't make sense, and so on. But also it shows, again, this narrow focus. The new buzzword is competitiveness. Okay, so best you are scrapping some laws, but you are not really making a clear plan. Okay, what is then the alternative? What does it mean for example, our companies, our European companies? If we want to improve competitiveness, is the existing liability system really a good fit? Is there not a problem that the liability risk is shifted downstream? Is this not maybe harmful to our economy? Those questions the Commission is so far completely unwilling to think about, which again brings me to the point that they have not learned at all from the mistakes of the past. So again, what we see right now in digital policy is basically a new narrative, but the approaches are still the same. Now it's just different terms: applied AI strategy, Digital Networks Act, and so on and so on. But since there was no structural change, we believe there will be similar outcomes. We will stay with an incoherent digital strategy with a lot of overlapping, duplicating, contradicting laws and initiatives. So unfortunately, from this, what we again thought, good wake-up call from Draghi letter and others, at least the Commission didn't learn that much. The European Parliament, and a few colleagues are here, I think we learned a little bit more. We actually also made similar statements cross-party-wise, really from far left to at least some parts of the far right, that we're all saying, okay, we need to change the ways we are doing our policies, our laws. We need to think broader. Maybe you saw it, that there is now a new mechanism of ad hoc committees that are hopefully in the future covering broad horizontal topics like the AI Act, like Green Deal legislation, and so on and so on. But still, the European Parliament, as always, is unfortunately highly divided. As soon as there's pressure from the European Commission, from others, we are often splitting in a lot of different teams and groups. And in the end, this is then an easy way to overrule us, to go in different directions that are not really the initial idea of at least the European Parliament. But again, as I would say, at least it's good that most of the political groups do understand that if we want to do something good for our economy, we need coherent laws. If we want to protect fundamental rights effectively, we need coherent laws. We also need effective enforcement. We have already a lot of legislation and rules out there, but if we are not enforcing them, if we are especially not enforcing them because of political reasons, we spoke a little bit before the panel about it, this is not helpful, and again, the consequence should not be to just replicate then what is already there, because if you are not enforcing, the fifth law is not making it better. And maybe as I make the round through all EU institutions, I'm now here for 12 years, what I find really striking is compared to the Juncker period, where the council, maybe it was also because I was more a young professional and I was more impressed by the council back then, but I would argue back then the digital attachés that are mostly really, really good, had a lot of feedback from capitals, got really clear instructions what to do here, and so on and so on. Of course, similar to the European Parliament, also the Council was always divided, is still divided, and so on. But you really see that those poor digital attachés are often not having any input from Paris. Berlin is never giving input, so the German attaché, the German vote, you know the word, is always in the unknown what he or she should ask for. But this is really a more systemic problem over the last, I would say, at least since COVID, that the Council is not really taking place. And we saw it in the European AI Act discussions. We see it now with GDPR enforcement regulations that the Greens are currently leading, and we are part as shadow rapporteur. And again, if you are thinking about my initial point, a coherent legislative approach that is really touching up on all the different angles, on all the different fields, well, in the European Parliament, it's tricky. We are all not having huge capacities, small teams, and so on. If the Commission is not doing it, it would be basically the Council that could be the safeguards that hopefully would be able to bring all those different national ministries together. But as I said, at least my impression in the digital field, it's also getting worse and worse. And again, it's really not the people here, they are trying everything, but it's this lack of information and maybe also lack of interest for European politics from many national governments. And this brings me to a final remark and conclusion, and I will use it a little bit to make a small advertisement for a recent published publication with 35 plus authors from civil society, Mercator to Sebastian Heinzleben, academia, Philip Hacker, people that I often work with, where we basically, all of us kind of united in being completely annoyed and angry about this lack of coherence, this lack of progress here in Brussels. We were basically proposing for the Commission to finally really build up this overarching digital vision, policy vision. To be fair, there are already a lot of elements. We didn't really create very new things. Mostly we basically copy-pasted from all those fragments that are there, the digital decade, the declaration on digital rights, the AI strategy, data strategy, and so on, put it together, and we feel with such overall or overarching digital policy strategy, most of those problems that I have mentioned could be fixed. And then on top, a second part in our paper is really with the Draghi Report, with geopolitical pressures and problems and maybe demands to really rethink certain approaches, all of us, all those 35 plus authors, really thought, okay, now there's momentum, now we really need to go a step forward. The time for big reforms is now, capital market union, banking union, like Draghi was saying, but also on a lot of other things, just to give you one example or two, on governance, we all think the Commission, as I criticized them already a lot, is not doing a good job in drafting laws, in reviewing laws, and so on. So all of us, for example, were proposing to withdraw the regulatory scrutiny board from the Commission, make them independent, and let them really run an independent process to check the laws. I was talking about enforcement, and the Greens and I and a few others are very much pushing, or part of the Greens to be fair, for a digital enforcement agency, because again, we think that political enforcement is definitely not working, and such an independent EU agency would probably do a much better job. And as a final point of our 18 proposals is really to finally go forward on digital skills. It's a bit problematic, as you all know, because its European treaty is not giving our level a lot of competences, which is why we proposed a so-called sovereignty compact. So basically re-establishing this idea of a Europe of different speeds, so that those countries that are willing to give up certain national competences would then benefit a lot from European funding, from other advantages, and those member states that don't want to be progressively going forward, but stay to their national approaches, of course, would be out, but could join at a later stage. We really feel that it's now time to do all of that, and again, that it's really now time to finally overcome this, especially in the digital field, incoherent way of policy making, because on all the topics that we are talking about, if we are not changing that, we will not really see progress on all those fronts.
Thank you so much. And then last but certainly not least, Dr. Stasi, especially because we have been talking about expanding the tools in our toolbox, which I'm sure is something that you are also able to speak to expertly.
Thank you very much. Thank you for being here, all of you. It looks like I have a lot to say, but I can't see well, so it's a big font. Also, I mean, a lot has been said already, so I feel like in the privileged position of standing on the shoulders of giants. I also have a burden here because I think I'm the only, openly civil society representative at this table. And I have to say, you're the captain of the ship. So so I've heard a lot of very good points, but I need, obviously, I need to present a different perspective. And although I would love to sort of reinsert fundamental rights into this discussion by saying, mentioning fundamental rights, what I'm going to end up is going to be about raising 4 main points that I think could help this audience and other stakeholders to understand what kind of situation we face and what we, meaning civil society, or at least some of the civil society, and what kind of challenges we're dealing with to be part of this conversation. The first one is about the narrative. When we talk about AI, I mean, Seda has mentioned some part of it. Kai has now focused on other elements. But when we talk about the narrative, the general narrative is, what we hear is growth, sovereignty, security. European securitization is everywhere. And it seems to be like that we need to scale up as Europe. We need to scale up. Tech companies need to scale up for both security and competition. Competitiveness is another one. I need to use brackets because I am almost sure that if I ask each of you, what do you mean by competitiveness, we're going to come up with different feedback. So it's a huge umbrella term, but there is a lot of confusion, I would say, to say the least, about what we mean by that. Sometimes, in the best case scenario, there is reference to fairness, but once again, it's not really very well defined. So when we talk about we need more AI or we need to advance, et cetera, for this reason or for that reason or for that reason, what are we actually saying? I'm not surprised that this is happening because AI is now at the center of a number of different policies. But if you think about it, it might be defense, it might be trade, it might be industrial policy. It's definitely not at the center of social policies. This is, or to better say, sometimes social policies are mentioned, human rights are mentioned, but there's sort of a side effect or a complementary argument. I think they're rarely the driver. I remember as a civil society, like 4, 5, 7 years ago, many of us were engaged into this effort of ethical AI, ethical codes, ethics was everywhere. And a few of us, we were saying, well, we actually have an international human rights framework. We don't need ethical commitment to go with. Now, we forgot also about the ethical, I think. But anyway, the main point is, to this, there is an addition, which I think is, and I really hope we're going to have time for this conversation. The addition is, regulation or rules, they're taming innovation, they're slowing down innovation, we need to simplify, we need to deregulate. Apparently, last night, the US Budget Committee said, yeah, well, maybe this idea of, putting on hold, having a moratorium on AI regulation for 10 years, it might be good, because then we can really be fast and get where we want to get. So this is the narrative we face. And if you are a civil society organization and you try to get into this discussion, it's difficult, because trade policy is not somewhere where you would call a fundamental right organization to discuss it with. Defense, even less so. Innovation, growth, it's not our comfort zone. We're not invited, and sometimes when we knock the door, it's just closed, and closed it remains. There is also a huge capacity issue. From the substantial perspective and from a resource perspective. Substantial because this is not easy. If I didn't have SEDA or people like SEDA to sort of instill all this knowledge into my brain, I'm a policy person, I'm a competition lawyer by expertise. How can I understand what is going on? Definitely, civil society doesn't have available all the expertise to sort of dive in and show to policymakers or to regulators or to society what kind of impact we're actually talking about. There is a lack of information, there is a lack of transparency. To a certain extent, when we talk about specific kind of AI, some scholars, some people have been bold enough to say, we have an epistemic capture. We only know what these companies are letting us know, and we need to create a counterpower. So it is a real barrier, a real challenge. And then in terms of resources, everywhere we're discussing AI. There is the Global Digital Compact, the UN High-Level Advisory Board on AI. OECD has come out with recommendations. We have the Council of Europe AI Treaty. We have the EU AI Act. We have national initiatives. In Brazil, there is the AI strategy. In India, AI strategy. Everywhere we go. We're a few people. It's as simple as that. We can't compete with the army of representatives that are sitting on all these tables. So, and here I do have a positive message to drop accidentally, which is we are a few, but we coordinate well. And when we do it properly, then we can reach a lot of stuff and a lot of fora. But this is another challenge. Then from a regulatory perspective, I'm super happy Maria is here, because obviously we're talking about increasingly overlapping regulatory space. So when we do have rules that deal with all this, the point is, how do we deal with this overlaps and interactions? And I've heard a call for coherent application, a call for cooperation, a call for independence as well. I think they are all very good drivers. Probably what I would add is that the cooperation or the consistency, they won't lead us where we need to go without having being able to embrace a more holistic assessment. If the different regulators, they go in silos and they think this is a privacy problem or data protection problem, then I step in. This is an online safety issue, then I can go in. This is a competition issue, then probably, but they remain very fragmented. I think we're not going to be able to grasp where the problem lies. I think scholars, they can be extremely helpful in this exercise. Now I'm going to be very EU focused, but just to give you a couple of examples, I've recently read papers and suggestions by the academic community about possible overlaps between the GDPR and the AI Act when it comes to processing special categories of personal data, and how do we need to do, in case of risk mitigation purposes, in high-risk systems under the AI Act. There is a lot of discussion to have about substantial public interest grounds. Is this going to be enough? Is this not going to be enough? There is this discussion about possible nomination of ChatGPT and surrounding as very large online platforms under the DSA. So obviously we're moving there. We're moving fast, and there is a lot of room for research, and I think it's a good development. But there is much more to be done. There is much more to be done. And I think there civil society can play a role. For the simple reason, because Maria, you mentioned that sometimes the Commission brings the fundamental rights perspective to this cooperation forum. I think there is a lot of expertise that is needed at this table, but I also think the fundamental rights perspective is not the core of any of the regulators we're talking about. So maybe civil society can bring this into the table. My last point is extremely more concrete and focus on one specific instrument, which is my background, competition and antitrust. If we think about it, there have been many competition authorities already investigating in a way or in another AI and behaviors in the sector, from tying, bundling, lock-in, switching barriers, etc. So there is a lot of interest. There have been guidelines, also the FTC, DOJ, CMA, EC, they came together with joint statements. There is commitment, there is interest. But there are 2 points in here. The first one is competition won't solve the situation by itself. It's not just if we get it right with competition remedies, then we are okay. But also, we will never get where we want to get. We will never have an AI which is human rights centric if we don't solve the monopoly power or the concentration of power that we have underneath. So I think while I wouldn't agree with these calls that only competition can solve the issue, I also need to be very, very careful that if we don't have this, then we're wasting our time for everything else. Thank you.
Thank you so much. That does indeed merit an applause. In the interest of time, I will be asking the panel one single question for each of you to just briefly address, and then open it up to the audience, because I already saw a number of hands shoot up during the individual remarks, and I do think that that is the most interesting way to move this conversation forward. I do really appreciate, Isa, that you mentioned the different themes that you're hearing, so coordination, cooperation, but also this real need of a North Star, of a sense of who are we as a potential community of values, and can we make sure that we keep that central to develop the coherence and the coordination that subsequently flows from that. And on that note, I wanted to ask all of you to briefly respond to the question of how can we ensure that particular fundamental values remain central to these debates about technology governance as the European Union is shifting its focus towards industrial policy and competitiveness. And maybe we can sort of go from what is your left to the right. So Seda, all yours.
Wow, it's such an easy question. Thank you. Love it. Okay. So I think if it wasn't clear, I was pointing at two major transformations. One is the institutional one, and the other one is the economic. And I think what I would say is that we, working on and cherishing fundamental rights, sometimes underestimate how much a role institutions play for us to be able to hold fundamental rights, right? So if we don't have educational institutions, if we don't have health institutions, if we don't have a good judiciary, et cetera, all of these public institutions, not always public, but if we don't have them in place, then fundamental rights are going to be very difficult to uphold. Therefore, a move to the cloud for me is a transformation of institutions that should be evaluated with respect to their ability to uphold fundamental rights for society. I know that's a very weird way of looking at fundamental rights, but I think we underestimate the role of institutions. For the economic one, and I think the Draghi Report is kind of exemplary, as well as the Emirates, who said they would now put 600 billion into AI. There's this kind of idea that if we, it's like the trickle-down economy, but we'll just, put a lot of investment into competitiveness and military, and somehow it will come down to a good competitive society, or Europe will be strong. Not a project I am aligned with. But I think what we see is that there's already a sort of structural economic inequality that's built into these infrastructures. And by putting more money, either government money or in public-private partnerships, we're probably going to intensify that kind of economic inequality. And I think there's been a kind of split in fundamental rights where we said economic rights is different from, fundamental rights. But I think we need to put those two pieces together to address this thing. Otherwise, we can have whatever, not that I believe in it, but fair and whatever respecting AI, but we'll be in a very structurally unequal society. And I don't think that is actually an aspiration we should have. Thank you.
Thank you. Maria, can I hand it over to you?
Thank you very much. So I think I talked, when I spoke earlier, quite a lot about cooperation and collaboration and the importance of partnerships. I think the heart of the regulatory framework, and Kai talked about this a bit as well, is this concept of transparency. But alongside with transparency, we also need to be able to demonstrate that we hold the regulated entities to account. The accountability part is really important. In order for us to do that in a way that puts fundamental rights at the center of our approach and our thinking, I think we need a couple of things. To some extent, we need a form of education. It's important that every actor and every part of this regulatory framework that's been developed plays their part and helps us to do our work. That means civil society and academia and individuals making sure, and for us to find a way of making sure that they are empowered to bring to our attention the evidence base that is needed, that is specifically related to risks to fundamental rights, for us to then take regulatory action on behalf of the public and of our society. That's the role of regulators, as I understand it. So I think that kind of understanding, for everyone to understand what role they are playing and to be able to be empowered to be funded, to be empowered to play those roles. Otherwise, the regulatory framework will not hold. Some people have also mentioned to me the need for political leadership in this regard as well. As an independent, non-governmental body, we are not. We stay away from. We are politically neutral and we stay away from political debates. But I think it is the case that a sense of direction and a sense of mission needs to be imparted to us in order for us to be able to continue that accountability part of what we are responsible for.
Thank you. Isa?
That's indeed very tricky. So maybe two things, because we've been talking about the institutions and the role of regulators, and I think we need both, definitely. So it's not the first time that we're trying to make big companies accountable. And the UN guiding principles have been a good exercise, but I think we all agree, or many of us agree, that they don't have teeth. And the bigger the company, the less easy it is to sort of convince them to act in the public interest. So I think I need to go back to the competition issue before, and I need to stress that as long as the power is so concentrated, it's going to be very difficult to have a different kind of narrative and a different kind of conversation. I also think that to debunk this narrative, we need to know much more. I think there is a knowledge capture, and it's not necessarily only because of what I said, the civil society has struggled to get access to the public debate. Also people, which means users or consumers as well, they don't have the information they need to make their own choices, and then they don't have the choices. And so it's very difficult to have a serious fundamental rights perspective because it's always presented as either or. And it doesn't need to be the way. You can get good services and your fundamental rights respected. It's just, this is not the common conversation now. And I do believe that to regain this right is a lot about what we know and what we've been told.
Perfect. Kai?
Yeah. So I agree with a lot what has been said, and therefore would really focus now on AI governance, on the AI Act, and again on my role as representative here of the EU institutions. First of all, and I will again begin more positive and then talk about things that can maybe be improved. In the AI Act, I think, despite all the flaws, and you know that I am quite critical on certain things, I think for a digital law, we actually, especially when it comes to fundamental rights, made a lot of good steps and a lot of improvements, again, especially if compared to the previous generation of digital laws. Think about the fundamental right impact assessment. Yes, my group never really liked it because of potential overlaps with the data protection impact assessment, but it really depends now on the European Commission, on the template that is being developed, if this is really then something that is complementary, that is helping, and it will definitely bring or make sure, not bring back, it will make sure that fundamental rights, despite the talk on competitiveness in Brussels and other stuff, will play a major role in the enforcement and implementation of the AI Act. Second point, we also, in the negotiations, especially the Parliament, and also here, it was really nice to see a cross-party alignment, really wanted to go away from this kind of closed-up Brussels that the Commission or member states are deciding everything by themselves. We created the advisory forum, the scientific panel. There are a lot of consultations, maybe even too much at the moment, especially when we are talking about capacities from civil society organizations. But there are a lot of chances to bring in your feedback, to finger point to certain things that are going wrong, where human rights are being violated, and so on and so on. And the Commission, but also the member states, are no longer able to just brush it off and say we will ignore it. We made it a little bit more tricky to not take it into account, and hopefully it's working. And to the point with governance and enforcement, also here we really try to learn from the past. We are criticizing the AI office from time to time, but one thing where they are definitely doing quite well compared to other units in the European Commission, that they are now finally really reaching out to other silos. So the AI people on AI and Cloud Act, not yet, but at least with fundamental rights, we hear that there's a lot of talk with the DSA team, even with the Fundamental Rights Agency. Finally, there is a start of a dialogue, data protection authorities, and so on. And here I'm always making a reference to the UK, but also to Ireland. I only know the name in the UK, Digital Regulation Coordination Forum. If we don't go for a digital enforcement agency, like we proposed in our paper, I think at least such a coordination framework makes a lot of sense, and again, to your question, would make sure that fundamental rights cannot be overlooked, because in the enforcement of the AI Act or of a special other type of law, fundamental rights doesn't play a role. No, such a network would make sure that always all different enforcers are being heard. Very shortly, just 3 points that can be improved. I said already, at least us, and here really Axel and myself and a few others in the EPP, we really think that even a coordination forum is not enough. We talked about market imbalance, we talked about lack of talent for public authorities and so on. We think if you want really to have a chance against a super powerful company, it's probably only workable in Brussels. If there is really an independent body, a little bit like FCA in the United States, well, to some extent at least, the old one, but we really think that there should be a body with a lot of expertise, with a lot of personnel and so on, probably in order to make sure that now the Commission is not using deregulation, simplification and so on to sideline fundamental rights in the enforcement, for example, of the AI Act. It would be probably wise to increase the role of the European Parliament in secondary legislation, comitology, for example. So far, only member states are attending. I don't like that for a long time because it's an isolated body. A lot of stuff is happening there that is often going against the will of the co-legislators. Let's say at least Brando Benify, for example, I think should be there in order to check that comitology is going in a good direction. And then really final point, I said already, or I praised already the European Declaration on Digital Rights and Principles. I truly believe that it was a very, very good and balanced document. But as I said at the very beginning, unfortunately, it didn't really play a role in any of the legislations that we put forward. Again, some people in the AI negotiations and myself were trying everything to put in references, to make sure that also sustainability is playing a bigger role, and so on and so on. From several people, there was always the response, we do not care about it, it's a different unit, it's a different DG, and so on and so on. Again, when we are talking about a bigger vision, a coherent vision, going away from work silos, and again, strengthening fundamental rights, I think here we should really start and use this really good declaration and kind of integrate it in all of our laws.
Thank you. These were excellent answers that I'm sure have generated a lot of additional questions. Front row prerogative. Here you go.
Thank you, Luca Bertuzzi, MLEX. I have a question for Ms. Donde. So there has been a lot of talk about how the AI Act enforcement could draw lessons from the GDPR. But at the level of governance, the AI Act is much more similar to the DSA than any other digital law. And so especially in Ireland, that has taken a dispersed approach to AI governance. What I see are two levels of coordination at the national level and at the international level with EU counterparts for cross-border cases. And to make things even more complicated, there is no country of origin principle in the AI Act. So as the DSC for Ireland, how do you see this challenge in terms of coordination? What are the lessons that we can draw from the DSA enforcement, especially since you said that there is this learning curve on how you regulate risk? Thank you.
Shall I go ahead, or do you want to? Thank you very much for the question. It's a really good question, and I have lots to say about it. I'll try and keep it brief because I'm sure there are many more. Firstly, I just wanted to come back to the point actually that Kai made about and you also mentioned national level coordination. I think national level coordination is incredibly important. There is an equivalent to the DRCF in Ireland. It's called the DRG, and there are some of these groups emerging around Europe and around the rest of the world. And we also coordinate. So we have our coordination of coordinators. If you like, at the international level. And the things that we talk about, in fact, we had a meeting just yesterday, and we were talking about exactly these sorts of questions. You know, for example, how do regulators talk as one voice with large platforms across sectors and so on? That's really, really a big part of what I think will be critical for the AI Act. Now, in terms of what lessons can be drawn, it is early days, and I'm always a little bit wary of sort of being, you know, kind of ideas being attributed to us as one DSC about you know, the concerns or something like that there's not happening enough. I would say that coordination between digital regulators within the Digital Services Board and under the stewardship of the European Commission is going well. It's a really positive exercise. I think you'll hear more and more from the Digital Services Board, particularly this year. It's been in existence for just over a year. We are working very closely together. it's not without its challenges. But for example, soon the board will be publishing its report on systemic risk, and I think that's something I would encourage you all to look out for. It's the culmination of work that's done by all of the digital service coordinators and the European Commission to assess and analyse and understand the initial risk assessment reports coming out from the platform. So I suppose that the main lessons are to ensure and to put into place as early as possible frameworks for cooperation at the EU level between regulators. It's really, really critical. It will be critical. It's also particularly important because the types of regulators, in some cases new organizations, in some cases ones who are new to certain aspects of the kinds of things that we have now responsibility for, means that we really need to learn from each other. So it is really helpful, I think, in the DSA context that we have a group of digital service coordinators who come from different backgrounds. Some, as I said, and I said this before, we have media regulators, we have telecoms regulators, we have competition regulators, we have consumer authorities. All of those participate in the board, and we are all really enthusiastically learning from each other, including the European Commission, who is also to some extent, although not completely, but to some extent new to this type of regulatory approach as well. So I want to not underplay the challenges, but certainly I also want to stress the real positives and to urge everyone to keep an eye on the Digital Services Board, because I think a lot more will be coming from it. Thank you.
We had one more question in the front, and then I think we can take one more before rounding off.
Thank you. Joe Pearson, Hasselt University School of Social Sciences. I have a question for Seda Gerses. So thanks for the thought-provoking opening word. It's a bleak picture, I must say. So, and therefore my question, how do we resist? What are there ways to resist this evolution? Or is resistance futile? Just that's the question. And possibly it's around stronger institutions. If you talk about institutional level, possibly it's about cooperation between oversight boards. But I don't know.
Yeah, I mean, that's the million-dollar question. By now it's a billion-dollar question, right? Like there's so much inflation of numbers these days. I think the paths we see forward are the following, and the first is easier than the second, I think. And the first is, this is an infrastructure, and infrastructures take decades to build. So they're slow-moving. They're not fast-moving like AI, which went from machine learning, deep learning, LLMs to agentic AI, and tomorrow it'll be something else. Like that's moving too fast. But if you look at the infrastructures, it actually moves very slow. And I think there's a way in which the separation between societal concerns and economic concerns is really working against us. So to look at the economic environment from a societal, including fundamental rights perspective, what this infrastructure is, I think is going to be very valuable. And to also not confuse, these companies have been doing the same thing for 70 years. That's what I just claimed, right? Like we can put a hole in that in some way. And some companies do more software and some others do more hardware, et cetera. Like it's complex. But I feel like if we just stop believing that they are doing something new every day, but just look at what they've been doing for a long time, we can actually handle them better, right? Instead of making a lot of incoherent laws about the newest thing, which is coming out of the same space, right? And I think that is maybe like a helpful hook for how to think, so like a more sort of grounded understanding of what these companies do. So that's number one. Number two, the more difficult one, is I think what we saw in the AI Action Summit, et cetera, is not only a silencing of civil society, or gaslighting, if you wish to call it that, but also like just lip service to something like sustainability or really like a fundamental transformation in society was acted like it's not, and it was as if like as a society our responsibility is to make sure we can build more AI, right? Like that was kind of the transformation we saw there as a conversation. And I think what we need is a vision of society that is not tech-centric, right? And I think that means, I'm going to argue we can't afford this technology, right? We can't afford replicating it because we don't have 600 billion from the Emirates coming into Europe, right? And we can't afford it because, just redoing it on our own terms, we don't have the money. We also don't have the financial movements that make it work. And we can't afford it because our environment is not doing well right now, right? So that means we need to put, I think, questions of structural justice and environment and a vision for not just Europe, but a world, into a vision for technology, not the other way around. Right now, technology is leading both the money and the transformation, and we need to find ways to have a vision and maybe think about a technology that fits that vision rather than drives it. So that's a harder one, right? But I'm just putting it out there.
We can do one more if we can keep it brief. I have one in the back here.
Thank you. I'm Maria Maggiore from Investigate Europe. I have a question perhaps for Kai. You talked about the need of a new agency, enforcement agency. How can you guarantee that this agency can be independent from a big platform? Because what we are seeing is that all the implementation of the AI Act is now controlled a lot by sponsors also of this conference. And linked to that, if somebody else wants to add something, we are also seeing the presence of big companies in the standardization tables. Do you think it was a mistake from the Commission to give the mandate to these tables instead of doing itself, perhaps with a better control of the Parliament to the comitology, as you rightly said, this very important standardization process when it comes to high-risk products? Thank you very much.
Kai, I might ask you to answer one and not both questions in the interest of time.
Okay. Oh, this is difficult because I like both. Let me just think. Yeah, maybe then on the agency. So the political groups probably have different reasons why some of them do prefer such an agency. From our side, Axel and mine personally, it's really look at what happened with Thierry Breton and Twitter, for example. It's we are both not fans of a political European Commission because an enforcer should be neutral, should be objective, should not make politics, should not look for photos. One thing that we now also criticized with the code of practice, where the Commission leadership is so much looking for getting signatures for a shiny picture with model providers that they are willing to water down the language in the code of practice. Those things should not happen. Of course, they can always happen. No new institution or new agency is well protected against everything. But again, just by taking it away from the political level of the European Commission, where unfortunately now also the code of practice lays, is in our opinion already a good thing. On top then, of course, as I said, more resources, more probably better talent, more talent, and so on and so on, and also the possibility to focus on long-term topics. As you know, the European Commission thinks in 5 years or even less with the European elections. Thus, such a new agency could do it much longer, could really investigate some systemic structural problems and so on, and therefore being completely disconnected from the policy cycle. And just a last sentence, sorry, look a little bit at ENISA. ENISA is not all great. Many things are also not working, but comparable, or BEREC, and we really hope, again, Axel and me, that BEREC is now not being killed by the Digital Network Act, because we like what BEREC is doing, we like that they are more critical, and this is something that we would probably also like to see if such a digital enforcement agency focusing on AI, data and platforms would really be created.
Thank you. If I can just conclude by going from the very granular to the bigger picture that Seda was sketching in terms of our collective vision for non-tech society. I hope that is something we can all walk away with today. And then I just wanted to thank Mark Dempsey of Article 19 and Dina van Geest, who've been really instrumental in putting this panel together. And of course, all of you for joining and sharing your perspective, and everyone in the audience. So a round of applause is in order for everyone.